Christina Taft versus Javonte Thomas.
Hello, Your Honor. It's Christina Taft.
According to your statement of claim filed on May 19th, in this case against Javonte Thomas, you allege that you hired a defendant to provide public relations services, including media outreach, press release distribution, and interviewing scheduling. You allege that he owes you $1,200 for failure to perform contractual obligations, essentially a material breach of contract. So upon reviewing of the subpoena ducis tecum, the court did not understand why you were requesting phone documents from a person by the name of Angela Gail Meter. And then upon further review of your subpoena ducis tecum and the alleged legal authority and justification for it, you cite TRO cases in the Third Circuit against another non-party named Mr. Baresi. The court went ahead and looked up those cases and saw that, you specifically cited 3 DSS 25044, and the judge in that case dismissed it. So that called question into the court's mind as to your intentions of filing these subpoena ducis tecum that appear to be completely unrelated to Mr. Thomas's case as your publicist. I don't understand how an alleged harassment case against Mr. Baresi has anything to do with Ms. Meter's phone records, and how that has anything to do with the fact that you're allegedly suing Mr. Thomas for breach of contract.
Because his contract was to reach out about my U.S. district case in Central California, which is still ongoing. We were reaching out to reporters regarding artist safety and Baresi's documented harms to witnesses.
It appears to the court that what you're doing is you're using the legal system in an unrelated case to get another person's confidential personal information through their phone records. And I'm saying this because I also looked up the docket and looked up your filing history in the First Circuit as well as the Third Circuit, and I noticed that you did the same thing in other cases, where you would file subpoena ducis tecums for people's phone records that have nothing to do with the cases that you're filing. And for that reason, I am ordering you to show cause today why you should not be deemed a vexatious litigant by what appears to the court to be engaging in frivolous discovery tactics and subjecting and subject to pre-filing order and other relief requested. In the filings that you filed, you mentioned something about T-Mobile faxing you or mailing you things. Did you actually receive any of Ms. Meter's phone records from T-Mobile?
Yes, I received a year of records from 2025 to 2024, which showed that Baresi called her or there was some interaction.
Where are those records?
They're emailed to me from T-Mobile.
They were emailed to you?
Yes.
So T-Mobile did not follow the court's subpoena order, because the subpoena order commands an agent of T-Mobile to appear in court to hand over the documents, which they did not do. They just sent it to you via email. You filed a 26-page document under and signed it under Rule 11. How did you write this? Did you use AI? And in writing this, did you read any of the case law that you cited to, or any of the rules of law that you cited to? For example, if I were to ask you to tell me what the case T-Mobile Inc. and AT&T Corp. stands for, can you explain that to me? Can you tell me what that case is about?
That case is related to phone records and privacy and responding to subpoenas.
Used artificial intelligence, perhaps, or it was not written by an attorney. For example, on page 3, you cite Hawaii Rules of Civil Procedure Rule 45C3A to state that any challenge to a subpoena must be raised by a party or recipient via a duly filed motion to quash or modify. And you cite this alleging that the court has no authority to sua sponte, quash, or set aside the subpoenas that I did. There is no such thing as HRCP Rule 45C3A. It does not exist. It does not exist, ma'am. You cited a completely non-existent rule of law. So how is the court to believe that anything that you're saying is not frivolous?
From what I understand from when I subpoenaed T-Mobile records against Paul Baresi is that they're
citing law that does not exist. I'm telling you that the Hawaii Rules of Civil Procedure Rule 45C3A, which you cited to multiple times in your document, is non-existent. Does not exist. All right, so again, Ms. Taft, the court has ordered you to show cause why you should not be deemed a vexatious litigant by your history of filing cases and also within those cases filing subpoena ducis tecum for people's personal phone records that don't appear to be related to the cases that are filed. For example, in this particular case, again, you filed a complaint against Javonte Thomas for $1,200 for a breach of contract, and you're asking for 2 separate subpoena ducis tecum of a whole year of someone's confidential personal text messages and information. I don't see how that is, again, relevant. It appears to the court that it was frivolous, and it also appears to the court that you're engaging in, again, frivolous discovery tactics. So I'm going to give you one last statement to show cause why you should not be deemed a vexatious litigant. I will tell you right now that all of the explanations that you just gave me is not persuasive to the court.
right, Your Honor.
And again, I'm saying this based on looking at your filing history in the First Circuit, Third Circuit, and in this case before the court today. There appears to be a pattern. And the pattern is frivolous discovery tactics.
I was still trying to prove my harassment case to understand what's going on in my situation. And also, I filed with good faith that I am protecting people from harassment and harm. I did not know that Hawaii doesn't typically listen to issues from the mainland and regarding to California, but unfortunately, since Baresi wasn't in Hawaii, I couldn't receive a permanent restraining order, which I didn't realize was something that was a Hawaii issue. Unfortunately,
Third Circuit, didn't you tell the judge that Barasi lived in Hilo and your process server was still attempting to look for him in Hilo?
the wording was that my process server wanted to look for him in Hilo.
So why did you tell another court on the Big Island that the reason that you needed continuances was because your process server was looking for his address in Hilo?
Because apparently it's a higher standard for restraining orders here. And so I had to say and, see if he will come here, if he would escalate to that, or if he had followed me here. Part of the reason is because Baresi is related to, he uses people's names from Hollywood and things like that. And I guess they think, well, usually people can get a restraining order easily, but I haven't been able to. I had to learn how to do declarations where I had to do.
All right, Ms. Taft, I'm going to stop you only because I asked you to give me an order to show cause as to how the subpoena duces tecums requesting Ms. Meter's personal information. You specifically requested 12 months, her information from June 2023 to June 2024, plus the most recent month. I don't see how that's, I mean, you asked for text message logs, and you still haven't shown the court how that is relevant to the case against Mr. Thomas, and you haven't explained to the court why you did this in the First Circuit and the Third Circuit as well. So it still appears to the court that you are trying to get people's personal information through the phone company of their text messages and their phone history for a whole year that appears to be unrelated to the cases that you're filing these subpoena duces tecums for. So you have not shown the court good cause that you should not be deemed a vexatious litigant. You have not shown the court that you have not filed these subpoenas to conduct unnecessary discovery, or that you engaged in any other tactics that are frivolous. And so I am finding that you are a vexatious litigant under 634J subsection 3. And I'm also going to enter a pre-filing order prohibiting you from filing any new litigation in the courts of this state on your own behalf without first obtaining leave of the presiding court where the litigation is proposed to be filed. Additionally, I'm going to issue a monetary sanction in the amount of $100 for citing law that does not exist. And that will be paid to the clerk of the court forthwith.